Good afternoon, everybody. This is Lorraine Alternative Homesteading. I hope everybody's doing well. It is Sunday, March 19th, 2023. It is 3:20 p.m. And this adorable little painting is by Saulite, Saulite, and you can locate her on eBay. I presented a short yesterday on this new book called Forbidden Tech, the complete guide to energy, social, and biological technologies that they did not want you to know about, by Naima Morris and Tivon Rivers. So I'm looking through the book, and I was going to send a list of patents that came across my email yesterday, but before I do that, I want to read a little bit about what the patent process is, okay? And in their stellar book, they have a section on the patent trap, okay? So the patent trap, the patent is a temporary government-granted monopoly right on something made by an inventor. This monopoly period usually lasts about 20 years. While there are many types of patents, the most well-known type is the utility patent, which protects inventions. There are also design patents and plant patents, such as those utilized by Monsanto. Yes, Monsanto has genetically modified seeds. Okay. Historical purposes of patents. The historical purpose of the patent system was to encourage the development of new inventions by helping inventors feel that they had some protection from theft of their invention. Inventors are often hesitant to reveal the details of their invention for fear that someone else might copy it. This leads to keeping inventions secret and impedes innovation. Now, I'm going to tell you, folks, that if you're a targeted person, any of your ideas are already stolen from you by these criminals that remote neural monitor and spy on you. So this is a huge, huge issue amongst intellectual property theft, okay? So a patent was meant to alleviate this fear and was intended to allow others to copy their invention after a 20-year period had passed. This would also allow the inventor to recoup the investments he made during the development of his invention. It was also intended that after the patent was put into the public domain, this would allow others to add improvements and innovations to the original design. Applying for patents can be very expensive, especially when doing so in multiple countries. This is usually something that only large companies can afford. Small inventors will often only apply for patents in their own country. And in many cases, the patent office process can take up to several years. As a workaround, many small inventions are quote-unquote patent pending on their products. However, this is a loophole option which many may not be as effective in the future as it was in the past. The difference between a patent and a copyright is that a copyright protects an individual expression of an idea and does not protect against the independent redevelopment of that idea as patents do. A copyright lasts for 75 years after the death of the copyright owner. The problem with modern-day patent system, this is probably one of the least known misunderstood things about an inventor what an inventor can come up against when applying for patents. The general thinking is if you had a free energy device that works, you would get both $1 million and the patent. There are many stories that talk about how an inventor discovered something promising and then suddenly disappeared. The problem is that the patent system has been changed to create a trap that confiscates inventions and forbids inventors from further developing. There are over 5,000 patents censored that have to do with quote-unquote free energy devices. And let me turn the page here, folks. And I'm learning as I'm going here, too. I I'm reading this for the first time, and I wanted to put this out there so that you understand a little bit more about patents, the process. The U.S. Patent Office classification system has a 9-member committee that screens patents in order to protect, quote unquote, you guessed it, folks, national security. Another purpose of this committee is to find and remove from public access energy-related patents that could threaten the fossil fuel and power monopolies. Anytime someone applies for a patent, it goes through the screening process. If the device has anything to do with the production of free energy, they classify it, confiscate it, conceal it in a vault, and forbid the inventor to produce it. Now, I'm learning this for the first time, folks, and I'm wondering if that's what happens to my father's invention. My father worked for IBM in the International Research Department, and he invented a carbine. Yes, folks, he never patented it, even though he talked about doing so, probably because he worked for IBM, and the research scientists there stole his idea, and they patented it, and it is trading on the New York Stock Exchange, but I won't go into that because I can't. Okay? Secrecy orders. The inventor will then receive the following secrecy order notice. This is really interesting, folks. I'd never heard of this, but it kind of makes sense, okay? So this is a secrecy order notice that goes to the person that submitted the patents for review. It's Title 35, the U.S. Code 1952, Sections 181 to 188. Notice to the applicant named above, his heirs, or any and all of his assignees, attorneys, and agents hereinafter designated principals. You are hereby notified that your application as above identified has been found to contain subject matter, the unauthorized disclosure of which might be detrimental to, ta-da, national security, and you are ordered in no wise to publish or disclose this invention or any material information with respect hereto, including hitherto unpublished details of the subject matter of said application in any way to any persons not cognizant of the invention prior to the date of the order, including any employee of the principals, but to keep the same secret except by written consent first obtained by the Commissioner of Patents under the penalties of 35 U.S.C. 1952, 182, 186. Any other application already filed or hereafter filed which contains any significant part of the subject matter of the above identified application falls within the scope of this order. If such other application does not stand under the security order, it is common subject matter should be brought to the attention of the Security Group Licensing and Review Patent Office. If prior to the issuance of the secrecy order, any significant part of, let me turn the page, of the subject matter has been revealed to any person, the principal shall promptly inform such person of the secrecy order and the penalties for improper disclosure. Now, you know, I'm a little confused. Maybe my father did attempt to patent his device. And maybe he received one of these orders. I don't know. I was so young, folks. I was like 12 years old at the time. However, if such part of the subject matter was disclosed to any person in a foreign country, and my father worked with foreigners in the International Research Department at IBM, the foreign national in the United States, the principal shall not inform such person of the secrecy order, but instead shall promptly furnish to the Commissioner of Patents the following information to the extent not already furnished: the date of disclosure, the name and address of the disclosure, the identification of such part, or any authorization by the U.S. government agency to export such part. If the subject matter is included in any foreign patent application or patent, this should be identified. The principal shall comply with any related instructions of the Commissioner. This order should not be constructed in any way to mean that the government has adopted or contemplates adoption of the alleged invention disclosed in this application, nor is it any indication of the value of such invention. Did you just hear that, folks? Really? You kidding me? Do you believe that? I don't believe that for 1 minute. If an inventor proceeds with their invention after getting this notice, they can face up to 20 years in federal prison. In the documentary film entitled A Machine to Die For, The Quest for Free Energy, an ex-Secret Service agent assigned to electronic intelligence, whose identity was concealed in the film, made the following statement. If you're an idiot or try to go and patent your device, you're giving them all your information on where you are, how to find you, and they will try to find some legal mechanism to close you down. Oh, we don't know anything about that, folks. The Invention Secrecy Act of 1951 is a body of United States federal law designated to prevent disclosure of new inventions and technologies that, in the opinion of the selected federal agencies, present a possible threat to, fill in the blank, folks, national security of the United States. Yeah, so like if you invent some wonderful device to, let's see, like a new chicken door, that may pose a threat to national security. The U.S. government has long sought to control the release of new technologies that might threaten the national defense and economic stability of the country. During World War I, Congress authorized the United States Patent and Trademark Office to classify certain defense-related patents. The initial effort lasted only for the duration of that war, but it was reimposed in October 1941 in anticipation of the U.S. entry into World War II, and patent secrecy orders were initially intended to remain effective for 2 years, beginning July 1, 1940, but were later extended for the duration of the war. I wonder how this is going to affect the coming war. Then, 10 years later, the Invention Secrecy Act of 1951 made such a patent secrecy permanent. The secrecy order stops the award of a patent and restricts the filing of foreign patents and orders that the invention be kept a secret and specifies procedures necessary for the inventor to take in order to prevent disclosure of ideas contained in the patent application. I wonder if Nikola Tesla received such a letter. Do you think he received a letter and then he was murdered? Like, how do you think that worked? I look forward to your questions and comments down below. This is really interesting. Again, folks, I'm reading this for the first time, and the only reason I'm putting this out there is because I'm going to post something after this that might be of interest to everybody. The only way an inventor can avoid the risk of such imposed secrecy is to forego patent protection. So over 5,000 patents are censored. In 1991, there were 6,193 patent secrecy orders issued, mostly on private citizens and independent inventors. I guess they would never slap one of these on a corporation, right, folks? As the orders need to be renewed on an annual basis, a yearly basis, the number of orders has shrunk over the years. And as of today, there are still over 5,000 patents censored. There are mainstream and government-funded labs and research and education. And in today's society, the typical training for engineer follows some certain systematic criteria. Many institutions have a specific budget to do research and pay for equipment, and in schools, an engineer in training can learn how to do proper measurements, how to properly collect data, and to see how it correlates to any kind of expected outcome. And in case of errors, you usually have what you need to fix the problem. But most of the mainstream scientific research and higher education systems today are funded by government grants and corporate interests. And such funding comes with a set of rules and regulations that must be followed in order to continue to receive that funding, even if the rules are unreasonable. So if someone in the command chain makes a decision not to teach a certain topic, that topic is omitted from the body of knowledge. Uh-oh, that's not good. If someone objects and wants to push forward and teach the topic, well, we all know the outcome to this question, folks, then that department might lose its funding. Ta-da! What a surprise. Are you surprised? If you don't go along to get along, you're slapped with take away your money. This reality behind the curriculum is rarely, if ever, discussed. Instead, it is assumed that the body of knowledge is incorrect and doesn't exist. Oh yeah, you know what they'll do? They'll call it pseudoscience. I experienced that in my graduate degree program. When they were declaring certain topics as pseudoscience, like, holistic, alternative ways of treating illness. Pseudoscience, folks, they're teaching it in the textbooks. Yes, I couldn't deal with it. In some cases, as will be discussed later in this book, what is considered to be science has been decided by a vote. So I'm going to end on that note, and I hope you find this as interesting as I do, because I didn't know a lot of this information. The topic of patents is continued in this book. I highly recommend the book. This is it, Forbidden Tech. And this is Lorraine Alternative Homesteading signing off for now.